Your Excellencies, distinguished guests and dear colleagues and friends, it's certainly an honour to be invited to say a few words at the launch of Dr. Stahn's book. And I congratulate him and all those who were involved in its preparation. I've been struck from the contributions I've read by the frankness and the honesty and the rigour with which the many challenges facing the court and the history of the court are addressed in the book, and I'm absolutely certain it will be a key volume for the future. I've tried to pick out 3 or 4 broad, high-level themes from the chapters I've read and from what I know of the work of the court. I think they're themes that emerged from the court's first 13 years, and I think they will probably continue to be themes into the future. Those themes are credibility, legitimacy, the tension between idealism and reality, and then the court as a necessary being or a necessary entity. Credibility. This is probably the key theme. The very final chapter by Philipp Ambach looks at the lessons learned from the court's first 10 years following the conclusion of the Lubanga trial. One of the main criticisms of the court back then was the accusation that after 10 years the court had concluded just one trial, and that was still subject to appeal at that point, having spent the best part of €1 billion, and that it took 6 years from Lubanga's arrest to the first instance conviction. Things certainly look different now. 3 years later, we have 3 final judgments, with German Katanga issuing an apology to the victims of his crimes, and the trial chamber is due to issue its 4th verdict in the Bemba case, hopefully later this year. In addition, the court is moving to permanent premises next year, where it will conduct 4, or where it is capable of conducting 4 simultaneous trials. The court is approaching maturity and full capacity. But of course there is work to do. The President has stated that expediting trials is her number 1 priority, and from the point of view of the states parties to the court, we're certainly happy to hear this, because proper expeditious justice is central to the credibility of the court around the world and key to its deterrent effect. It's essential to ensure justice for victims, and that's a vital element of a fair trial. Now, we certainly acknowledge that states have a huge part to play in ensuring a credible court. The Rome Statute system will succeed or fail, based in large part on the cooperation and the work of the states parties to it. There are nowhere near enough witness protection or sentence enforcement agreements. There are too many fugitives at large. The Rome Statute system is a partnership between the court and the states. The court is trying to play its part, and the states parties who set it up must certainly play theirs. The second theme is legitimacy, and I hardly need to talk about the biggest challenge the court faces in this area, and that's the fact that many, if not all of its situations, are African. The chapter on this in the book is one of the strongest and most striking chapters. Case selectivity is dealt with in the book also in 2 opposing chapters, one by Fabrizio Guariglia and Emeric Roggi on the one hand, a view from the inside, and by Professor Bill Shabas on the other, challenging the practice of the Office of the Prosecutor. Of course, there is a ready answer to the anti-Africa criticism, or the criticism that the court is focused only in Africa, and that's that the majority of the situations were self-referrals by African states themselves. 2 were referred by the Security Council, and only 1 proprio motu reference, Kenya, and that was after the then prosecutor had waited a year for the domestic proceedings to begin. But there are some who will say that the court's legitimacy will only increase or will only be established when it opens a non-African situation. Bill Shabas and Paul Sales, in their chapters, imply that this should already have happened. I'm sure it will one day. If the ICC had been around 20 years ago, it would have been dealing for sure with genocide in Europe. The court is here to ensure justice for the victims of the worst crimes, and this includes African victims. So over the years, I've been struck by African NGOs' presence at the assemblies of states parties and by the powerful contribution they made, and by their support for the ICC and its work in the region. But again, there are concerns, and again, there is a role for states. It's quite clear that the court's effective legitimacy is undermined by the fact that only 2 of the permanent members of the Security Council are members of the court. and yet the Council can refer situations to the prosecutor and veto referrals even where there are situations involving the most horrific crimes. And of course we see the failure of the Security Council to follow up some of the referrals it has made. It's not just the fact that the majority of the permanent members are not party to the statute. While the majority of the world's states are members, the majority of the world's population is not protected by the provisions of the statute. And states have a duty to work towards universality of the Rome Statute to ensure the court's legitimacy, and certainly that's a key part of the public position of the British government. The third theme is the tension between idealism and reality. As Professor Stahn says in a striking phrase, the ICC is a persistent object of faith. And that is clear from the contributions to this book, from the huge academic interest in the work of the ICC, from the huge interest among the legal profession in the work, and even from the fact that it features in contemporary fiction. Those of you who read Robert Harris's works, The Ghost, the ICC is a key player in that novel. So expectations are high, but of course delivery has disappointed. And it's easy to lash out at the apparent scapegoats, a Security Council which isn't structured enough in its dealings with the ICC, which uses the court, as one of the chapters refers to, which does not follow up its decisions with money or with coercion, and member states who refuse to pay on demand and who question the budgets. So there's a challenge of the idealism. But of course the ICC, and you might expect a government representative to say this, but the ICC does inhabit a world of realpolitik, a world where ISIL do what they do, and where the great powers and the not so great powers act when they can and how they wish to protect what they see as their interests. This is a harsh environment for the delicate plant of international criminal justice. And of course it is also a world, and that's especially the case in my country and perhaps among many of the major donors to the court, a world of financial constraint, even for the court's most firm supporters. Now, faced with these challenges, it would be easy to despair. But I think it's very important to keep taking the long view and to keep in mind that this year's apparent crisis for the court, whether it's financial or whether it arises from the work of the court, is just that. It's an immediate crisis in a much bigger and longer historical perspective. Because, and this is my last point, the court is, in my view and in the view of my government, a necessary being. The ICC is here to stay. It may not have looked that way in the early years. I've been struck at the assemblies of states parties at seeing the size of some of the delegations of the non-state parties. Sometimes some of these delegations are bigger than the delegations of the states parties, which is surely a striking feature and a very important feature. The ICC is a fact of life. And another fact which you may find striking, it's not every day that North Korea lobbies the United Kingdom in London not to agree to an ICC referral. I mean, that may seem striking, but that is what happened last year. Now, of course, it may be that if we had the Rome Conference today, states parties would not have been able to agree on a statute or a statute in the form that we have. So in that sense, we should consider ourselves lucky that the timing was right and that we managed to establish a permanent international criminal court ready to try anyone, regardless of status. There will always be challenges, some of which I've mentioned, many of which are addressed in this excellent book, others which will emerge in future as the court goes on and develops. So the court and the states and the NGOs who support it, and the academics who write about it, and the legal practitioners who practice before it, must confront these challenges with clear-headed and clear-sighted realism, not least so that in another 5 years we're launching the next edition of the book by Dr. Stahn. So I congratulate Dr. Stahn and his colleagues on the production of the book. I urge you all to purchase a copy at the back of the room. Thank you very much, ladies and gentlemen.